9 justices can shape the future of 330 million Americans. Here's how. Right, let's talk about the Supreme Court. And look, I get it. The name itself sounds like something you'd find on the menu at a slightly too fancy Taco Bell. But this is important, because right now, in a big marble building in Washington, D.C., there are 9 people. That's it. 9. A group that could comfortably fit in a large minivan or uncomfortably in a regular-sized elevator. And these 9 individuals have the final say on the laws that govern over 330 million Americans. That is a frankly staggering ratio of power. It's like having the entire country's Netflix account controlled by your 9 weirdest relatives, and you just have to pray they don't decide everyone should only watch documentaries about competitive cheese rolling. The decisions these 9 justices make don't just affect some people, some of the time. They ripple through every aspect of American life, from the most public of policies to the most private of moments. They can determine who you can marry, what your rights are in the workplace, how you vote, and what you can and cannot do with your own body. It is an immense, almost terrifying level of influence concentrated in the hands of a group so small they could be outvoted by the starting lineup of a baseball team. It's a system that, when you stop and think about it for more than 5 seconds, seems absolutely bonkers. And yet, it's the bedrock of the entire American legal system. Think about it this way. Your local city council might have more members than the highest court in the land. The average high school student government probably has a more robust roster. But when this tiny committee of 9 dons their traditional black robes, which, let's be honest, makes them look like they're about to graduate from a very serious wizarding school, their rulings become the supreme law of the land. There is no higher appeal. There is no manager to speak to. This is the final boss of American law, and there are only 9 of them. It's a setup that demands our attention, because their choices, for better or worse, shape the reality for hundreds of millions of people. And the truly wild part is how little direct say the public has in any of this. You don't vote for them. You can't recall them if you think they're doing a rubbish job. They are in many ways the most powerful and least accountable figures in the entire federal government. So, we're all just passengers in a car being driven by 9 people we didn't choose, on a journey to a destination we might not have agreed to. And if that doesn't make you want to pay a little closer attention to who they are and how they got there, then I honestly don't know what will, because their every move matters, deeply. So, how does one land this unbelievably powerful job? Well, it's not like applying to be a barista. You can't just submit a resume and hope your latte art skills impress someone. The process is a 2-step political tango. First, the President of the United States gets to nominate someone. This happens whenever a justice retires, resigns, or, to put it delicately, shuffles off this mortal coil. The president picks a candidate, usually a highly respected judge or legal scholar, who they believe shares their general interpretation of the law. It's basically the most important job interview in the country, and the whole nation is watching. Once the president makes a pick, the nomination goes to the Senate for a process called confirmation. This is where things get truly theatrical. The nominee is subjected to intense hearings where senators grill them on their past rulings, their legal philosophy, and sometimes their high school yearbook entries. It's a high-stakes political drama where one side tries to paint the nominee as a brilliant legal mind, and the other tries to portray them as a villain who would outlaw puppies if given the chance. If the nominee gets a majority vote in the Senate, congratulations, they've landed the gig. They get the fancy robe and a seat at the big table. And here's the kicker. Once they are confirmed, Supreme Court justices serve for life. That's right. It's not a 4-year term or an 8-year term. It's a until you decide you've had enough or you stop breathing term. This is known as life tenure, and the idea behind it was actually quite noble. The framers of the Constitution wanted to insulate justices from the political pressures of the day. They figured if justices didn't have to worry about being re-elected or fired by a cranky president, they could make impartial decisions based solely on the law, free from the whims of public opinion or political threats. Of course, the reality of life tenure in the 21st century is a bit more complicated. Because justices serve for so long, often for decades, their appointments have become incredibly high-stakes battles. A single appointment can shape the direction of the court for a generation. A president might only get to appoint 1 or 2 justices during their time in office, but the impact of those choices will be felt long after they've left the White House. It turns every Supreme Court vacancy into a political Super Bowl, with both sides fighting tooth and nail because they know that the winner gets to influence American life for the next 30 years. It's less about impartial wisdom and more about locking in a long-term advantage. So, we have 9 people with lifetime appointments. But where does their actual power come from? It comes from a concept called judicial review. And this is the real superpower. Judicial review is the authority of the Supreme Court to look at a law passed by Congress, an action taken by the president, and say, nope, that's not allowed. It violates the Constitution. It's the ultimate check on the other 2 branches of government. It's like being the referee in a game where the players are constantly trying to invent their own rules. The court gets to blow the whistle and say, sorry, that's out of bounds. Now, you might think such an incredible power would be explicitly written into the Constitution in big, bold letters, maybe with some exclamation points. But you would be wrong. It's not in there, at least not directly. The Supreme Court essentially gave this power to itself in a landmark 1803 case called Marbury v. Madison. The details of the case are famously convoluted. Last-minute political appointments, a guy who didn't get his paperwork, but the outcome was monumental. Chief Justice John Marshall, in a brilliant piece of legal maneuvering, wrote the opinion that established the principle of judicial review. In essence, Marshall argued that if the Constitution is the supreme law of the land, if a regular law passed by Congress conflicts with the Constitution, then that law must be invalid. And who, he reasoned, is better suited to determine if a law conflicts with the Constitution than the judicial branch? It was a mic-drop moment that has echoed for over 2 centuries. Without judicial review, the Supreme Court would be little more than a high-level advisory panel. But with judicial review, the court's decisions are binding. When the Supreme Court declares a law unconstitutional, that law is struck down. It's gone. This power transforms the court into an active guardian of the Constitution. To understand the real-world impact of this power, you don't have to look far. Let's start with Brown v. Board of Education in 1954. Before this case, many states operated under a doctrine of separate but equal. In a unanimous decision, the Supreme Court declared that separate educational facilities are inherently unequal. From civil rights to personal freedoms, the court's choices redefine American life. It's not just a court, it's the guardian of the Constitution.